All right, welcome everyone. Happy Friday. We're towards the end of our virtual training series. Last year, I know this was one of the more exciting and popular presentations, the Intro to Crimmigration. So I'm really happy and thankful to Jenny for being with us today and taking the time to present. We were just talking about how even during COVID, the detained docket has been going, court has not stopped. So really appreciate her taking the time out of her busy schedule to speak with all of us today. Um, just to give an intro, Jenny Hernandez is a Crimmigration removal defense attorney heading up the Immigration Defense Unit at the City of Atlanta Office of the Public Defender, which officially launched in 2019. Previously, she's worked as the lead immigration attorney at the Metropolitan Public Defender Services office in Portland, Oregon. She was there from 2017 to 2019. And before that, she was an attorney advisor at the Miami Immigration Court from 2015 to 2017. She's a graduate with a dual degree with a JD and Master's in Theological Studies from Emory University, where she got both those degrees in 2012. So please join me in welcoming Ms. Hernandez. And if you can please put yourself on mute so that I have to do that because I have two kids running around somewhere around here. And stuffed animals. So put yourself on mute. And if you don't mind introducing yourself in the chat, just so we have an idea of who all is joining us, your name, what organization you're with, what city you're in, because I know folks are working remotely. And I know Jenny will maybe pausing in between to see if there are any questions, or feel free to put questions in the chat and we'll try to make sure there's time for Q&A at the end. So with that, I'll let Jenny get started.
Okay, good morning, everyone. And yeah, just know this to me is like a practical presentation of just kind of thinking about this intersection of criminal law and immigration, and how we as immigration attorneys have to deal with that, and then speak to criminal attorneys and deal with really complicated issues that can complicate someone's immigration status. And I see that there's 16 people in one. Okay, and I'm trying to just look at the chat to see who all is here, because I just like to have if you do just write your name and what organization you're with, that'd be great, so I can have a little background of who all's around. Because there's so many, I don't think we'll go around and ask each person, although it is strange to just be looking at you at a screen and not know, but thank you for joining. Cool. Thanks for writing. Okay, we got Tahare, Triple J, Gain. Cool. I see some people have some public defender background. Awesome. Okay. Well, hello, Jeff, Shelley, Eileen, Carmen, Sydney, Monique, Michelle, Ramona, Gabriella, Rama, and Ali, and I'm so One. I hope I said that. Okay, so I hope I said that right. Okay, awesome. Okay, so I think you guys know the drill. I'm going to put up my PowerPoint presentation, and I'm not going to be able to see people as much. But I hope I can still be personal with you and explain. And I'll try to pause and ask for questions. I guess can we unmute for questions? If I wanted people to during the time? That's
absolutely
how it works. Okay. All right. Well, let me share my screen and go for it. Okay, can you see, does that look good? Can you see my intro screen?
Yes.
Okay. Yes, I'm gonna hope that Shelley can tell me, because I can't see anything once I do this. Okay, so just to tell you a little bit more about what it actually is, an immigration attorney working in a public defender's office and this unit. what it is I do. So I'm at the City of Atlanta Public Defender Office. The Public Defender Office.
Pretty big now. Is there a way to shrink it so it's not?
Shrink the.
Are other folks seeing that?
Is that better? Is that better?
Are other folks seeing that? That it's like really large? Or maybe it's just me?
So, sorry, what's the issue?
It's like it's like really big, so I can't see the full slide. But it might just be on my screen. Is anyone else seeing that? Jeff, Onay, any of you? Oh, it's good? Okay, maybe that's what my issue is. Okay, never mind, no problem.
Okay. So right now it looks good because I kind of changed it a little bit. Can someone tell me just like it looks good right now?
It does, you can see the whole screen? Okay, it might just be on my end.
Okay, all right. Close up the slide. Yeah. That's what I tried to do. Did that make it bigger, Shelley?
Yeah, I might be messing with my computer a little bit and showing it as like really big so that I can't read it, but it seems like it's okay for everyone else. So
Okay, well, let me know if anyone types and says that it's not okay.
Okay, we'll
because I can't see their chat box anymore when I do this. Okay, so yes. I'm an immigration attorney that's practicing at a public defender office. And this is like our mission, and I'll break it down a little bit more. It says the Immigration Defense Unit will defend and uphold the basic human and civil rights and protections ensured to our non-citizen community members under international and U.S. law. The unit will address their two most essential immigration legal needs: representation for indigent persons who are in removal proceedings or deportation proceedings, and advisories and warnings of the immigration consequences, specifically with regards to deportability of pending criminal charges a non-citizen may be facing. And I'll get into that a little bit more, but I'll just say right now, I mean, it started off as a collaboration between the Mayor's Office of Immigrant Affairs, the Vera Institute of Justice gave us some initial funding, and then the Office of the Public Defender here. I am the attorney right now that's starting it. We hope to bring on another attorney maybe this year, and I have a legal assistant, Emily Braden. And so what we do to break down those two things, a public defender office, just obviously, I mean, I don't for you all in law school, is an office that's, criminal attorneys that for people who cannot afford an attorney facing the criminal charges, get appointed an attorney, and that's the public defender. That's the public defender office, and this is in the city of Atlanta for the municipal court here, which will hear either violations of city codes, which are criminal most of the time, and for some state crimes. And so that's what the attorneys here are hearing, and they'll have obviously non-citizen clients coming through who are facing those who are facing certain criminal charges. And criminal charges can really affect someone's immigration status or their ability to obtain immigration status. And so I am an immigration attorney that helps provide advisories and warnings about when those non-citizen clients are facing criminal charges, what that can do, like what's the best strategy for that case so that it has the least effect on their or on any future or pending immigration issues. Now that's one part of what I do, and then a main part, the bulk of my time is also taking on representation for persons who have Metro Atlanta ties and are detained at the Irwin Detention Center, which is about 2.5 hours away, and but their cases are pending at the Atlanta Immigration Court, which is just across the street from me. So I will take almost anyone who's detained. If they're detained, they just generally. Sorry, that's not the right statement. But if they have a lot of times they have criminal issues if they're detained and they're facing deportation. And so I've started providing representation. Obviously, the need is much greater than just one attorney, but for people who we do an analysis of their income and making sure that they're 200% below the poverty level, their household income, and that they have Metro Atlanta ties. And then I randomly will start selecting people to represent them in their actual deportation proceedings. So that's kind of what this program was like set up to do, and it was just seeing as how like one's liberties at stake, like even more so happen most of the time in the detained immigration removal proceedings, and that's what public defenders do, is like fighting for one's rights and liberties. And so many times it's tied to one's criminal history, what's happening to them in their immigration case. It's really becoming this like growing. It's becoming a growing trend across the nation, although very like it's still a pretty like new trend to have an immigration attorney like me, public defender office. So overview of the presentation, immigration and criminal law, how criminal history affects a person's immigration status. All these are going to be general concepts, and as I was just telling Shelley before, it's everything I say, immigration feels like it's changing like every 2 hours, but the law, the statutory law has not changed. Case law has been changing. Enforcement policy has been changing constantly. So, there's a lot that's changing. So everything always kind of feels like it's in flux. And everything I try to say, I'm saying is like, as best as I know it as today before some other case law decision, like something else. But the Immigration and Nationality Act, the main piece of law I have to go by, has not changed for a while. So we're going to go, that's number one, how criminal history affects a person's immigration status. Number two, the defense attorney dilemma, representing non-citizen clients. What I was just talking about when a criminal defense attorney has a non-citizen client facing criminal charges, and how they have to think about how that's going to affect their immigration status. And then we'll talk about ICE enforcement in the criminal justice system, ICE detainers, different policies that ICE has, and immigrant detention. And then Georgia law and policy regarding immigration too. Things I think you've all heard from like Project South if you watched their presentation on Monday, but 287G, anti-sanctuary statute, non-detainer policies. This is all like a really ambitious presentation to get done in an hour, so we'll see how far we get through. And I know that Project South touched on 3 and 4 in some sense, so we'll see. I'll see how deep we can get into it. Okay. Immigration and criminal law. So I just think it's really helpful because I know some of you are thinking about what do you want to do? What's your next stage going to be? What field of law do you want to go into? And it's just kind of like, if you have an interest in crimmigration and immigration, like kind of laying out the parameters of what each is doing. So I just like set this out here as kind of like a general idea of what I think about when we think about immigration. I say immigration is the field of law that sets the legal parameters for non-citizens regarding who may and may not enter U.S. borders and how they may enter, for how long they can remain in the U.S., and who may gain legal permanent residency and or citizenship. Immigration touches many areas of the law, and a person's immigration situation often affects their ability to pursue legal remedies such as what state and federal benefits they can get. The primary source of law is, as I mentioned, the Immigration and Nationality Act, and that's just the U.S. Code citation. For all these things about when you may enter the U.S., if you can stay, if you can become a citizen or legal permanent resident, your criminal history and convictions are going to matter. And they can have serious consequences on a non-citizen, on their immigration situation, wherever they are in one of those fields or what they're like trying to do. And then plus to keep in mind that there's many different legal statuses that a non-citizen can have, and all those statuses have different kinds of criminal requirements of how a criminal conviction may affect them. So that's where that analysis and thinking about that is kind of where I'm always living my life in my profession. And I just kind of put a reminder out here. It's a reminder in both the criminal and immigration system, a person's liberty can be restricted and they can be detained pending the resolution of their case. In many cases, the immigration process may be even more severe than the criminal process, as it can expel someone from the U.S. And however, in criminal proceedings, the Constitution guarantees one an attorney, but not in deportation proceedings. So as we talk about a public defender office is like here to, for those who can't afford representation before their criminal case. And that may just be like a little misdemeanor where like max you're facing maybe a day in jail or, you know, or a fine. And whereas like where you're facing deportation and detention, you are not guaranteed a right to an attorney and you may be expelled from the U.S. without ever having an attorney. And it's kind of like this movement, I think, about what public defenders do and how can we have a public defender mindset for the detention, for detained people to deportation proceedings where. So I just, this is probably a little too technical, but when we're thinking about someone's immigration status and how their crimes are going to affect their immigration situation, it's important to kind of just know these basic concepts that of an immigration process. Like one, when someone's getting admitted into the U.S., so they're outside the U.S. and they're trying to get in, and sometimes you may be in the U.S. and there's going to be an analysis on whether you're going to apply, whether you're admissible. Other times you're in the U.S. legally, you have a visa, but you want to then become a legal permanent resident. And then there's the naturalized citizenship when you're a legal permanent resident and you want to be a citizenship. All those stages, your criminal history is going to matter and can affect whether you can do each of those things. So how criminal convictions affect immigration status? I just talk about admissibility. I just say generally for a non-citizen to enter the U.S., obtain a visa, or to adjust their status, they must be admissible. However, there's like a part in the INA that specifically talks about inadmissibility as related to your criminal history, such as having any conviction for what they call a crime involving moral turpitude, or can make you inadmissible to the U.S. A conviction related to a controlled substance can make you inadmissible. And then a conviction of 2 or more offenses with aggregate sentence imposed of 5 or more years. So that's why sometimes there's waivers for different convictions, sometimes there's not. But all these things, whether or not you're admissible, is going to matter what you're convicted of and if they fit into these certain categories. There's also generally a lot of times in immigration assessment of good moral character or some kind of discretionary decision. And so your criminal history is going to come into effect when you have to prove some kind of good moral character, which you would have to do, for instance, citizen. There's other times you'd have to prove good moral character too, but that's one of the most common ones. And you can be, first of all, you're barred from becoming a citizen if you're on probation of any kind. It doesn't matter how minor the crime was. You can't become one if you have any what's called an aggravated felony. That's a technical, all these terms are technical terms that are in the INA. It's not just like, oh, any aggravated felony in any state. It's like if it's a specific kind, how the INA defines it. So all these are different. And then you see controlled substance conviction, 180 days of confinement total. All those things can be bars to good moral character. Then there's what I call special statuses in criminal history. So there's some statuses, and I never know how to explain it to people who don't practice immigration. What's the best way to explain it? But you guys have heard of DACA, you've heard of TPS, temporary protected status. These are like statuses that are totally discretionary at the whims of the government to give to you and are not a true form of status, but basically more of like some kind of deferred action of removal. Obviously, DACA is called deferred action of childhood arrival. TPS is temporary protected status, and it's always like temporary, and it can be rescinded. And both TPS and DACA can be rescinded based on your criminal history. So, for instance, I had a client just the other week who has been here since she was 2 and had DACA, but she got some DUI arrest and she's no longer eligible for DACA. Now, that is not the same thing. The DACA requirements are different than like being admissible to the U.S. requirements or being good moral character requirements. And same for TPS. TPS can be rescinded if you just have 2 misdemeanors. So that's not the same thing as, like, again, TPS's requirements, DACA requirements, they're all different than, like I said, the inadmissibility or the good moral character. So these are all things that when someone says a crime, you have to know their status to know, like, what you're going for. And then criminal conviction, even if you are here but you're not a U.S. citizen, a crime will just, like, can just make you deportable. So you could be a legal permanent resident, but, like, for instance, if you get a controlled substance conviction, then now you're deportable, and now the ICE can, like, seek to deport you. So that's also in the INA, and there's all these grounds for, like, what can make you deportable. I listed all these certain types of things. Again, I said not exhaustive, and how you define what is an aggravated felony, what is a controlled substance conviction, what is a crime of domestic violence. All of that is, like, takes a really intensive analysis going through case law, and case law changes frequently as to what constitutes the above crimes. And that's not even, and there's usually more requirements of, like, how someone was sentenced within that crime too, or how long had they been in the country before they got a crime involving moral turpitude. So you have to go look at the actual statute of the INA to see if it's going to make someone deportable, and then you have to go into case law. This all sounds really complicated, and that's because it is. And that says look at a handout, which I haven't, like, given you guys handout now. But basically, these things, like I said, what is a crime involving moral turpitude today may not be a crime involving moral turpitude tomorrow, because case law is defining what are those things and changing. Also, a way a criminal conviction can affect you. So when someone gets picked up by ICE to be deported, they can either fight their case detained or they can fight their case undetained. And obviously they all want to be undetained and not detained. But the INA mandates that there's certain crimes that, like, if you've been convicted of, you're in mandatory detention pending the resolution of your immigration case. So it doesn't matter how much family you have here or how much you have a really good case. If you have certain crimes, you could be subject to mandatory detention and just not even be eligible for bond, to request bond to get out of detention, which is really interesting when you think about certain things going on in our country right now, and that people can at least request bond if they have, really serious crimes. But under the INA, there's some crimes you can have that you just, like, absolutely can't even request bond. So, and criminal history, whether or not it puts you in mandatory detention or not, is always going to affect whether your bond assessment. So people get picked up by ICE and put into deportation at an immigration court, and then it's up to the immigration judge to decide whether they, whether they merit to be released. And the 2 factors are always flight risk and danger. And so flight risk a lot matters about, like, how much ties you have to the community, if you have other relatives with who are citizens, or you have children here. And then danger, they're always going to consider your criminal history. So even though your criminal history might not make you mandatory detention, if you have some, they can still consider you dangerous. So the big thing that's been causing a huge problem is case law has developed to say that DUIs are really dangerous. And DUIs are just very common. And so in the Atlanta Immigration Court, if you have, like, DUI arrest at all or anything, no matter, they're constantly being found to be a danger, and you can't get out to fight, and you can't get out of detention. You have to stay in detention while trying to fight your case. And I put, like, I know of at least one instance where even driving without a license has been found to be a danger, because it's like you're on the roads not doing what you're supposed to do, and so you're dangerous. All things, obviously, in the criminal context are not held to such this, like, high standard of what a danger is and you being subject to detention. I'm going to, hold on. I thought, just, like, Shelly, have you seen anything? I'm just going to take a pause for a minute, because that was all, like, a lot of information, and see if there's anything people, like, immediately want to ask right now, or I can keep going on, but that was we were just going through a lot. So I thought if anyone wants to type in a question or come in, or Shelly, I don't know if you've seen anyone do anything since I can't see you.
We explained about the fact that, immigrants are expected to be perfect in a way that we aren't. And just thinking about the number of college kids that get DUIs and the consequences for, a DACA recipient or a DACA eligible kid, the consequences. But does anyone have a question right now for Jenny, or should she keep going?
Yeah, Jenny, I have a question. So it seems like there's deportability and there's inadmissibility, and they have there's like different crimes that can make someone deportable versus inadmissible. Um, for like a total newbie, like why? Like why are they different?
Because Congress in 1996 decided to pass the law that way. So, I mean, I don't, there was just a huge push when the laws got way more strict in the 90s. That's what everyone was tough on crime. That's when we had to, and that's when a lot of this stuff got passed in terms of why they made inadmissibility more broad. Generally, it's more broad. So it's just, and then they made deportability, I'd say, a little bit more strict. There's actually more crime. It's a longer list that make you deportable, but they have sometimes they have stricter requirements. Whereas just one conviction of a crime involving moral turpitude can make you inadmissible, but a crime involving moral turpitude doesn't make you deportable. If you're a legal permanent resident, it only makes you deportable if it's within 5 years since you were admitted to the U.S. and it could be sentenced up to a year. Whereas that requirement isn't on the inadmissible side. So I think it's something about if you want, it seems to be some sort of rationale that coming to the U.S. it's going to be really broad, and then we'll make these really more specific requirements once you have status of what's going to make you deportable. The logic is somewhere in the 90s with Congress who passed this stuff that I don't even try to understand half the time. So, but that's, yeah, it's just, there's a specific ground of inadmissibilities listed in the INA, and there's specific grounds listed in the INA for removability, for deportability. So, but good question, yeah. If I could explain all the rationale of immigration law, I would. I would be more depressed because I really don't understand it half the time. But okay, so good question. I'm gonna keep going. When I should also clarify that if you don't have status, so if you don't, if you're undocumented, you don't have any status, you can always automatically go, not automatically, but if you're located by ICE, you can be put into deportation proceedings, and your charge is inadmissible just for not having status. And so then you're charged for not having status, and then it's about, well, if you can still apply for something to then give you status while you're in removal proceedings, while you're in deportation proceedings. And a lot will matter there. So, and then they'll come up with, and sometimes you'll be applying for things that it matters whether or not you have inadmissible crimes. So that becomes, once you're applying for relief in immigration court, your crimes will matter too. I think there's already been conversations this past week about just that basic concept of being inadmissible or being charged in immigration court and then getting to apply for relief. I think that's mainly only been talked about in an asylum context. You can definitely apply for other things, and almost always your criminal history matter whether or not you can then keep moving forward to get status. Does my slideshow still look okay right now, or?
Looks great.
Okay. All right. So here we are, factors affecting removability. So this kind of goes towards, when I'm saying this, I'm talking about the grounds of inadmissibility and the grounds of deportability, both which come up in removal proceedings. Things that will matter in that statute about the crimes will be the past criminal history, the length of the sentence. A lot of times, how you were sentenced matters, and like if your sentence was if you were put on probation but then it was revoked. Well, sometimes it'll matter what is the maximum possible sentence under the statute of the statute that you're convicted under. It doesn't matter if you got the maximum sentence, but sometimes just the maximum sentence will matter. Then there's like different parts of the statute. You'll have like there'll be different parts to like a battery statute. It's like, which part of the battery statute did you plead to? All those things will matter, and doing an analysis to see if they actually match to one of these grounds of removability in the INA or the inadmissibility. So that's kind of, again, for us to get really into this, it would be like a whole law class to like look at those statutes, look at those grounds, and do the analysis. I'm just trying to tell you like all the things that start coming up that you have to think about when you're doing this. So that's just like giving you this like, oh my God, there's like all these things that like when a non-citizen comes to you and you have a, now we're here at the slide, the defense attorney dilemma, representing non-citizen criminal cases. So you just imagine being a defense attorney, have no background in immigration, and you have a person come to you and they say that they were born in China. And so, and then you're like, okay, well, are you a U.S. citizen? And, they'll say no. And now you've got to figure out, I just told you, like, different statuses matter. All these different things matter. And you kind of have to think about where they are in this immigration situation and then what is the crime that they're facing. So that's the defense attorney dilemma. They have no background in any of this stuff. And now they have a non-citizen in front of them. They've got to figure out if they're an attorney that wants that their client is telling their immigration status matters, now they have to think about these things. And luckily, there became a Supreme Court case in 2010. It's called Padilla v. Kentucky, and it's kind of just like at the heart of crimmigration. That requires a criminal defense attorney to advise non-U.S. citizen criminal defendants of the risk of deportation regarding any plea that they enter. So incorrect advice or the failure to advise a non-citizen client of potential deportability consequences qualifies as deficient performances you can make for ineffective assistance of counsel under the Sixth Amendment. So Padilla came up with this rule saying when the deportability consequences are clear, that means that the INA says that this type of aggravated felony definitely makes you deportable. So, well, in the case of Padilla, what had happened, it had been a man who had been a legal permanent resident for like 30 years, and he pled to, I want to say, a cocaine conviction or something about possession of cocaine, I'm pretty sure. And his defense attorney had told him, oh, well, you've been here for such a long time, you'll be fine. Like literally, that's what the defense attorney just thought, that like he's been here for too many years, he's got to be protected, he'll be fine. And that was the general facts of Padilla. So then he pled to a controlled substance conviction, which made him deportable. And and he was, so now on appeal, he was insisting he never would have pled to that had he known that now ICE was going to try to deport him and he's going to be in deportation proceedings. So that issue of the attorney advising him incorrectly got taken up to the Supreme Court under a Sixth Amendment claim of ineffective assistance of counsel. And that's when you get this case where they say, well, when the deportability consequences are clear, the law is clear that the plea will make one deportable. The duty is on defense counsel to advise her client of this consequence. When the deportability consequences are not clear, the duty of defense counsel is to advise the plea may carry immigration consequences or may make them deportable. So, yeah, okay, Sydney, I'm going to go to your question. So, first of all, when the consequences are clear is all up room for debate. I know for a bunch of people. But for controlled substances, the INA just says any conviction related to a controlled substance. So it was just like very clear in this case. It did require that it's assuming that the defense attorney is going to actually go look up in the Immigration and Nationality Act the grounds of removability. It's also, Padilla also didn't choose to just say only if you misadvise them. It said that like you have to tell them when the law is clear that this can make them deportable before they plead, or the law is not clear that that it may make them deportable. So that was that's Padilla. Now I want to look at, so Sydney, I think we're going to go to this. The INA will a lot of times say when someone's been convicted. You don't always have to be convicted, but most of the time you have to be convicted. But the term conviction is defined in the INA as super broad. It says that you're convicted when a judge or jury has found, okay, this is the language of the INA, so these is the language of alien. When a judge or jury has found the alien guilty, or the alien has entered a plea of guilty or nolo contendere and has admitted sufficient facts to warrant a finding of guilt, and the judge has ordered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. So as soon as one admits to their guilt, if you look at that first prong, as soon as one enters a plea and the judge puts some form of punishment, that counts as a conviction. Now, Sydney just sent a question saying that would the Georgia first offender status affect immigration? Georgia first offender status. As far as I understand, with Georgia first offender, we don't deal with it too much in my here in my court, but you do have to enter a plea for first offender. And if you enter a plea on first offender, even if it's later dismissed, if you enter a plea and the judge puts some form of punishment, then that counts as a conviction. And that's the kind of tricks that things that like if a criminal defense attorney doesn't know that, they think like, oh, I've got you first offender, it's going to be okay. Those are it's not so easy once you start having to look at these definitions. Well, so if you look at the definition of conviction here on this slide, it says, or an alien has entered a plea of guilty or nolo contendere, or has admitted sufficient facts.
Okay.
So that's like, it's written right there in the INA for what it can be. Yeah. Let me just picture, yeah. Also, yeah, when I'm printing out terms of Shelley has mentioned, the INA is filled with the term alien. And when I'm quoting it, I use it. But, you know, I don't want to use that term, and most people don't use the term, and Shelley's mentioning that, like, actually a Supreme Court justice has decided to stop using it. So I don't ever use it when I'm not actually quoting the INA. Non-citizen is the term I'll usually say.
Kavanaugh did it. I was saying it. Yeah. I was like, I never thought Kavanaugh would make me happy, but.
So this gets more complicated, and I'm gonna let's go back to conviction and where it says any reference, because sometimes for something to make you removable, you have to be sentenced to, like, let's say a year of imprisonment, like that will be somewhere in the INA. And so this says any reference to a term of imprisonment of a sentence with respect to an offense is deemed to include the period of incarceration or confinement ordered by a court, regardless of any suspension of the imposition or execution of that imprisonment. So a lot of times judges will sentence people to like a year, but be like 10 months suspended, but they don't care. But like the INA doesn't care. As soon as the judge sentences you to that time, they can suspend it, but you've still been sentenced now up to a year, according to how the INA is understand. Now, Georgia has a really special issue about probated sentences that we don't have time to get into, so I'm going to skip that slide. So so this is all things the defense attorney has to think about. They have to think about structuring a plea because sometimes one part of the statute may be a crime involving moral turpitude, but maybe another part isn't. Maybe the sentence is really going to matter, and they have to make sure the way they do the sentence is going to really matter, and it's not like so they don't. I can't just read suspension because the defense attorney thinks they're doing a great job if it's suspended, but that's not really going to matter for the conviction. And then also, it's like for one ground of deportability is anyone who's been convicted of 2 crimes involving moral turpitude. So if you have a legal permanent resident and they only have 1 crime involving moral turpitude, sometimes just 1 won't make them deportable, but 2 definitely will. So now you have to think about what's their criminal history and how does that matter. And then I just always say, but basically, as soon as a non-citizen comes in contact with the criminal justice, there's always something to worry about in some sense, because there's always a discretionary element that an immigration judge or immigration services could take into consideration. Not always. There's sometimes in immigration where there is not discretion, but a lot of times there is, and so your criminal history is generally. I'm just going to skip this, but just know there's federal criminal immigration crimes that we're just not going to go. Here I say, thinking about crimmigration, the immigration practice of it all, and the criminal practice of it all. The immigration practice, like I have a client come to me that has criminal history and wants to fight their case. I have to identify their criminal history and how it's going to affect their goals for whatever they're trying to do in their immigration situation. And then I have to be able to tell them, well, you have this certain criminal history. Let me identify what you're eligible for and what you're not eligible for anymore. And then a lot of times I think that like the law could go one way or another if that crime makes them inadmissible or deportable. And I might have to brief or argue before the immigration judge or USCIS about why that certain crime doesn't make them deportable or. And then in the criminal practice, you have criminal defense attorneys trying to advise on what are the consequences of the conviction that someone might be pleading to on the immigration consequences. You have them trying to identify pleas that may have less that either don't have the deportation consequence or just have less of a consequence, and trying to make sure that the paperwork looks right. And you also, I say, post-conviction relief is really, that's when someone's pled to something, but you want to go and like undo it and say they weren't advised properly. That's those are things that post-conviction relief practice will like try to do. So we're at 11:43, and I'm trying to think about what's the I don't know. Let's just go to, I know y'all already talked about ICE detainers, but I'm just going to talk about them, how like we have to deal with the justice system. Because the criminal justice system is like the #1 way ICE identifies people that they want to take and put in deportation proceedings, removal proceedings. Again, ICE is the enforcement arm of the Department of Homeland Security. It's called ICE, Immigration Controls Enforcement, and they're like the ones tasked with, agents to like identify people who are not legally in the U.S. And so a lot of times the #1 way they'll try to find people is these people will be fingerprinted in the criminal justice system, and then they have systems to review those fingerprints against theirs to see like if that person has ever had any kind of immigration history, and are they out of status? Did they never get status? Like where are they? And then that's when that gets identified, and they see someone's being detained, in a certain jail, they will lodge an ICE detainer, and they will send a detainer to the jail and say like, we want this person when you're done with them. Like that's their detainer, that's their hold. And now the biggest thing about ICE detainer, but I'm assuming Project South got into this, I think you listened to it on Monday. One of the biggest issues with that is that they're telling you to hold on to this person with no probable cause finding or anything. They're just like asserting to the jail, like, hold on to this person, we want him, we have reasons to think so, but there's never been a finding from a judge if there's probable cause for them to hold on for ICE. And that's like the huge constitutional issue about detainers that slowly getting litigated, but there's never been a like super helpful decision on it. I don't want to say never. District courts are trying to figure out how they're going to deal with this. And written ICE, and of course, I don't know if you've ever heard of like, there was this famous case last year in Boston where a man, I don't know what his status was, but he wasn't a U.S. citizen, was up in a Boston court pleading before a judge, and a judge knew that ICE was outside ready to pick him up, and the judge let him exit out the side door of the courtroom and not the main courtroom. Well, now the U.S. Attorney's Office is prosecuting that judge. I don't actually know where that case stands right now. But they're under this administration, they're taking a really aggressive stance against the idea. The thing about this one is, he was in a courtroom and he was supposed to go out the way he came in, and now they're saying that, I can't remember what the charges were. I'm sure it's an obstruction charge or something. But that's like a really huge deal to go after. Like there was no like legitimate warrant. No, I don't know if the judge was convicted. I need to look up. I want to say it's still open.
This was an issue in Georgia, I know, with this judge named Sidney Nation in Rockdale County. He would actually want to call ICE on undocumented folks that entered the courtroom. This was back in 2011 or 2012, so I don't remember. I don't know the status of the law now, but he was actually, there was an appeal of his ability to do this, and the Georgia Court of Appeals or the Georgia Supreme Court said that Superior Court judges don't have jurisdiction, but I don't, this was before this administration. But what's really interesting to me, I think in Georgia, groups like GLAR and Project South that presented on Monday have been trying to get around the anti-sanctuary city policy by really just, I was telling them to just call it a Fourth Amendment policy where you're not going to agree to hold someone for ICE unless you have a warrant. And I remember city of Decatur, where I live, did that. And Casey Cagle, who was the lieutenant governor under our last governor, threatened to pull city funding. It's calling it a sanctuary law when it's really a Fourth Amendment requirement.
Georgia is a hotbed for all these issues, especially because you've got a city like Atlanta or a few other jurisdictions that like don't want to want to take more constitutionally we think more constitutionally correct positions on like ICE detainers. And then you've got governors and stuff who go the totally opposite way, and then you have so it's constantly it's Project South's like thing, they have a lot of things that they do, but thank God they exist and that they're following and doing it, because immigration attorneys don't have time to we take just the caseloads of the people. You don't have to, we're not constitutional lawyers to be going around and making all these arguments all the time, and they're never going to be. If you ever try to argue in immigration court that it was an unlawful detainer that brought someone's immigration, it better be the most egregious constitutional violation you can even think of. And even then, you don't even know if an immigration judge find the fact that that they were brought unconstitutionally. These are all issues that are just getting played out all the time here in Georgia, and the Project South is by far the people that are most up to date to it and following it county by county. Did Project South talk about 287G? I'm assuming you said so, right?
Yeah, they did.
Yeah. Well, I think what I'm going to do is 11:50. I think I'm just gonna like stop here. And because I've been talking for a long time, and I know I've just been giving like a lot of law stuff, and we didn't even get into any of the actual law. Like, I mean, I didn't like give you the statutes, but that's one thing I want to make clear is remember, just because something counts as a conviction doesn't mean that it's definitely going to be one of the inadmissibility grounds or one of the deportability grounds or anything. It's just that like it's really hard for anything not to be a conviction, outright dismissed under immigration law. So so just remember that there's these specific statutes listed that you're going to have to do an analysis of whether those types of things count. Whether like pleading to a battery or pleading to disorderly conduct, like do those different things and how they were sentenced. Does it count toward? Does it fit to what was brought up? What's in the inadmissibility grounds and what's in the removability grounds? Or if they have DACA, is it like DACA has totally different set of rules, types of crimes that can rescind. You have to think about that. These are just this is all just like to get your juices flowing and to think about all these different things. It's not to, no one should feel like they actually like learned some good substantive law today. It was just to show you like these are all the issues and things that pop up all the time as like we're going through this field. So yeah, if anyone has any like questions in like the few minutes we have left over, I'm glad to answer.
Yeah, this is great. We have a good amount of time for questions if folks want to unmute and ask Jenny any questions.
Yeah, sure. I have a question. Unmute my video here. Hi. So you mentioned that Georgia considers traffic violations misdemeanors, and a certain number of misdemeanors can make someone, I don't remember if it's inadmissible or removable. But like,
yeah. So no, it's not that. So the INA almost never makes a decision. But no, what it was, that was listed for temporary protected status. Mm-hmm. 2 misdemeanors could rescind a TPS. So people could so there's not a binding decision on this. Judges have gone either way, both ways here. Whether they find 2 Georgia traffic misdemeanors to count as 2 misdemeanors that would rescind someone's TPS, or not. But there's not a published decision on it. It's kind of, I know that immigrants have been able to win that issue and find that like that wasn't the intent of TPS, for just because Georgia calls it a misdemeanor, that like a traffic violation. But we also think it's been able to go the other way, where they have found that like traffic violation as a misdemeanor. So it's not, but there's not a decision on it.
So there's a similar analysis as to like a CIMT or an aggravated felony. There's a similar possible, just no published precedent.
No, so crime involving moral turpitude, there is case law,
right,
defining what a crime involving, but again, it doesn't. And then there will be case law on certain state statutes. So there's, you will find, and these case law is through the Board of Immigration Appeals, which is an appellate court within our solely within our immigration system. An appellate board, that will make precedent decisions that we're binded by. And they have that court, but it always has to be a specific statute has to be brought before them. And they may make a binding decision whether something is IMT or not, or whether it's an aggravated felony. But I mean, think about the like whole host of like, this is like for every state, because it's like every criminal code in every state. The Board of Immigration Appeals is never going to make like a binding decision on every single statute, every criminal statute in like every state. But the ones that they do make on usually get pretty good. It'll help you get, like, if they made a decision on like 3rd-degree assault in New York, then if the Georgia one is similar and there's not really any way to distinguish it, you probably know that 3rd-degree assault in Georgia is also a CIMT. So it's kind of like how you have to look at the case law.
Well, thanks.
Yeah.
Anyone else have questions? We still have about 5 minutes.
I think the most important thing is to know that I was just trying to like throw legal concepts at you, and all of this takes a lot of like. This took me like years to just really make sure to understand how make sure something is a CIMT or an aggravated felony or all these different. It takes a long time to just like get into the case law and get into the analysis of it all, and that's what a big part of this type of practice is.
Hi, Jenny. Thanks for,
Go
sorry.
Go for it.
Thank you, Jenny, for giving this presentation. I have a question. I know that City of Atlanta is one of the few offices in Georgia who actually has a crimmigration unit. And I've heard things about like DCAB trying to establish the same, but I know that it's unique kind of in Georgia. Do you think there is a trend of public defender's offices having a unit like this? And do you think there is voices like trying to advocate for that? Are you guys trying to do that?
Yeah. So as far as I know, I'm the only attorney doing something in the state of Georgia. Like I'm the only immigration attorney at it. There is, and yeah, I was in a public defender office in Portland, Oregon before that being this kind of exact same position. So, and there's more, and like the San Francisco and New York have like way bigger practices of public defender offices. So yeah, it's definitely a trend. I mean, but it's it costs money and it costs public funding, and being able to see it happen. I think one thing that's more common is to actually just have an attorney that is only advising on the criminal cases, but ones who are actually taking representation before people who are in detention or removal proceedings, that's less common. That's more. I mean, that's happening. It's it's slowly happening, but actually just having attorneys just be able to advise and help. That's the largest. That's more of a growing trend that you'll see, because Padilla v. Kentucky did put this constitutional standard out there that has been justifying public defender offices being able to like find some funding to get immigration attorneys to help advise. But actual taking representation on is a much smaller trend. They really, you just see in terms of a public defender office being involved, I know of San Francisco and New York, and now here. And I may be missing one or two others, but I don't think so. But yeah. Yeah, it's kind of where I've decided to place my career, and where I would love for it to be a much greater practice. Well, I would love to see the laws change and not be so like stringent, but yeah, it's where it is a growing field, and it's one that needs a lot of push to like fight the machine of mass detention.
So for someone, sorry.
No, go ahead.
So for someone who's actually trying to go into this field, would you recommend focusing on immigration law now or criminal defense? I don't know, like how would you go about, or how did you do it? Sorry.
Yeah, well, how I did it is not necessarily how I would recommend it. But I actually didn't, I learned immigration. I think it's such a technical field of law. I think you should definitely, if you know you're interested, and even if you know you're more interested in the criminal side, but you want to be able to like understand all this, I would definitely recommend it. I think what was really helpful for me, and the reason I felt like comfortable getting into this field was after law school, I worked as a clerk in the immigration courts, and the immigration courts are constantly. I worked as a clerk to the immigration judges. And I was doing these analysis for them all the time because people were being brought before them as deportable because of their criminal histories. And then the immigration judge has to like do the analysis for it. So I would do the research and do the analysis. And I think, so it's called, you apply to that through, the courts actually all exist within the Department of Justice. So you work for the Department of Justice within these courts. And that's how I really got my foothold into this. But I think, and you can also intern at those courts over a summer. I think really becoming familiar with removal and being able to see what criminal histories do to people is really important. But taking immigration law, if you really like the criminal side, I mean, a public defender's office, to be a public defender's office, I think, for the criminal side, even if you want to go private, just I think you're going to see like way more, as many issues as possible and see all the challenges there. And yeah, I think like if I were to be crafting this from law school, I would have taken every immigration course possible. I would have taken Crim Pro and Crim. I took Crim Pro and Crim, but and I would have interned probably at the immigration court, at the public defender's office, and also for an immigration who does removal, who does deportability, and like because a lot of immigration attorneys just won't talk to people. I mean, their practice just isn't focused on people with criminal histories because there's a ton of immigration to do that doesn't have any of these complications if you don't have criminal history. And they will refer out people with criminal histories to different other immigration attorneys to deal with it. So working with an immigration attorney who will specifically deal with people too, because many times people don't want to, that's just not where their practice is because they know it's a complicated field.
Well, we're right at noon. I know everyone really appreciates Jenny, you taking the time to talk to us. This is really fascinating, even for practitioners, not just law students. So really appreciate you, and we'll have this recording hopefully available soon, and I'll share it on the Georgia Immigration Working Group. Folks, feel free to email me. I'll put my email in the chat. Feel free to email me if you want the recording and for whatever reason you don't get it. So with that, we have another presentation today at 2, same link, from Amy Hauer at Catholic Charity. She's going to be talking about public charge and family petitions. And then on Monday, Kids in Need of Defense, GAIN, and Tahare, the 3 social services managers at those 3 organizations, are going to be presenting on providing social services to the immigrant community here in Georgia. Both of those presentations are super critical, super important, so I hope you all can join us. Thank you again, Jenny. I'm going to go ahead and stop recording, and thanks to everyone that joined in today.